Good night, Belizeans at home and abroad. My name is Leonard Brackett. I will be your host for tonight Belizean Affairs program number 283. 283. We're grateful for those of you who will be joining us tonight. We hope we present a worthy program of your time and for also those who will be listening to us at their own convenience. Again, uh, I'll be your host, and we usually start our program with a short word of prayer, after which we do a short biblical reading. I'll just bow my head and offer a word of prayer. Divine loving Father, we come before thy presence once more, asking that thou would continue to abide with us, that thou would continue to give us health, strength, courage, endurance, perseverance, wisdom, knowledge, and understanding, and the fortitude to continue on this journey with our Belizean Affairs program. Please bless us, whatever we have to offer to our public, may it be to thy honor and glory as well. Please continue to abide with us now and always, for we ask these mercies in Jesus' name. Amen. I'll just proceed to do a short reading. I'm going to pick a reading from, let's see, not done yet. I'll read from Proverbs chapter 6, starting at verse 1. My son, if thou be if thou my son, if thou be surety for thy friend, that is, in other words, if you put up yourself as a surety on behalf of a friend, uh, if thou hast stricken thy hand with a stranger, that is to make an agreement with a stranger, like to shake your right hand or whatever. It says, Thou art uh, thou art snared with the words of thy mouth, which is to say, make a promise and then unable to fulfill it. Thou art taken with the words of thy mouth. That is, you have given your word and you gotta comply, stick to your word, be honest. And so, therefore, that's the ending of our reading for tonight. We will stick to our word. We made a promise that we'll continue this program, and we made a promise that we'll try and bring to you things that are relevant to Belize and Belizeans at home and abroad. And we pursue that endeavor with no holds bar. Therefore, I'd like to normally we'll give a little caution, social commentary in regards to what's going on in the country. And what I've seen posted lately is quite a bit of accidents, car accidents, motorcycle accidents. You know, people are going to celebrate and they are drowning in rivers and other puddles of pools of water. And unfortunately, we're losing too many loved ones, and those who are staying behind have to deal with the grief and the cost of burial, as well as the cost of maintaining those who are left without parents. It's a tragedy, and we keep on advocating on this platform every time before we start our program as a caution to our Belizean people at home and abroad, and I would say generally to the public, because it's just sad that too many people are getting hurt and losing their lives and limbs because of recklessness on the part of themselves and or others. And I won't belabor the point anymore because obviously belaboring it isn't going to help me or help no one else. The fact that we raised the point should be good enough, at least for some people, to take caution. And I'm tempted to believe that there are those who are conscientious and who take caution. But then, for those who don't want to hear or don't want to listen or don't think that nobody should tell them nothing, how they should live their lives, what they should do with their lives, and they just want to go ahead and be reckless, it's unfortunate because it's those who are left behind that suffers. Good night. Thank you very much for your time spared. I'll proceed into the program for tonight. Uh, Recently, we've been talking about a particular case that is currently in the hands of the judge. Uh, all the hearing was had from the case, and the judge held over his decision. It was presumed or anticipated that the ruling would have been sometime last week. It didn't happen last week. Today is Monday, first day of this week. It hasn't happened yet either. So we're looking for it forward to tomorrow or some other day during the course of this week, or whenever the judge thinks that he is willing and able to pursue his responsibilities and deliver a judgment. Nevertheless, the way the case was being managed, from what we can see of the historical documents submitted and argued, verbal arguments and whatever else not, it seems to me personally, because I'm taking on this task personally right now to deal with this matter, I take umbrage to the idea that the case should have been managed the way it was managed. Of course, that's not my prerogative, that's the prerogative of the judge. But based on what I understand our laws in the country are, based on what I understand to be the practices, the principles, the everything that goes into these cases, which includes former cases that had been decided and which have become what you call stare decisis case and or settled law cases, which allows us to have an expectation of a certainty of law and judges ruling according to law. Because, of course, that's what the Constitution requires them to do. And in this instance, it's not just a regular case. This was a constitutional case that on its face had merits without anybody taking it up. The government should not have transgressed the Constitution in the first place and continue to transgress it. Basically, for more than a decade now, it's been done like that. And it seems like the people that we elect as leaders in our country could care less whether there's a constitution or not. They have no fidelity to it. They don't abide by it. They don't apparently believe in it. They don't operate as if they have a constitution that they are beholden to. So I'll just slow down a little bit on the prefacing of what I'm about to say and just go ahead and try and say as much as I can within the limited time that I have, which is it's now 9 minutes after. So I believe I have 21 minutes, 1 hour and 21 minutes left, because it's a 1 hour and 30 minutes show. And the material that I have available is quite extensive, and I'd just like to do the best I can under the circumstance. Let me do a little bit more prefacing. I need to, because so that people can get an idea of what is it that I'm referring to. We had a case, which was case number let me see case number here. I'm trying to find. Let me check case number here. Just give me a second, please. Got some notes to myself. I need to. The case that I referred to just now, that is still not that still has not been ruled upon yet, is case number 730 of 2024, by a judge, by under a judge by the name of Honduras, and the plaintiff in that case was Mr. Uh, Rudy Lewinsky Wade and some others, but he was the primary mover of that particular case. And we had the next case which preceded that, and that was case number 55 of 2019. In the beginning, or in the first instance, in this particular case of 2019, case number 55 of the Belize Supreme Court or High Court of Belize, the plaintiff in that particular instance alleged that the government was in contravention of the Constitution. That is, they were violative, their conduct was violative of the Constitution. And as a government, they should not find themselves or put themselves in that situation to be acting as scofflaws. Because many of them in cabinet were lawyers and still are, some are still lawyers. And they should have known that what they were doing was wrong, as acknowledged by the gentleman that was the head of the opposition at the time, who is now current Prime Minister, Mr. John Briceño. At the time when he was opposition leader in 2019, he was running around with the opposition people claiming that the government then in power needed to be taken out of power because they were not abiding by the Constitution. And he was alleging that if he became elected, that he was going to follow the Constitution and do what was required of the government to do in terms of making amends to these transgressions that were going on at the time. He got elected in 2020, and he proceeded to act as if he did not make a promise to the people, and as if the Constitution has no authority or power over him, under which he is supposed to be governing. As a matter of fact, the gentleman was so contemptuous to the Belizean people and the Constitution of Belize, by the way, which is the supreme law of the land. He was so contemptuous to the point of putting together a committee and going to the House of Representatives to get that committee authorized to be able to withdraw funds from the government treasury in order for that committee to go around the country, have enough resources to go around the country to so-called educate the people about what is it that was in the Constitution. Because 90% of the people in Belize have no idea what their Constitution consists of. And therefore, under the guise of offering to go and have this committee launch an education campaign, they went to the House, and in order to justify getting the money out of the consolidated fund, they legalized the committee then, in other words. Okay? They wrote a piece of legislation to give authority to the committee to be able to get paid, and for the committee to go and solicit from the general public ideas about what they want to change in the Constitution and what they want to either put in or take out. When in fact, the very same gentleman and his colleagues who had gotten elected had their own agenda which they refused to expose or enlighten the public about. All they wanted was to have the public's acquiescence to agree to the idea that they should go ahead and tamper with the Constitution. And when I say like that, tamper with the Constitution, is because currently, as the legislative body of the country, they are empowered under the present Constitution to make amendments to the Constitution, so long as those amendments comport the constitutional constraints and are not violative of the Constitution. They can make modifications, here, there, and around the edges. But there are certain part of the Constitution that they are prohibited from tampering with and or from writing out of existence and or making changes wholesale to the point where the Constitution then is rendered mute and or silent and or invalid. In other words, to operate or run the country in a form of dictatorial manner and not abide by the constitutional constraints of the country. In other words, not accepting the premise that you have the three branches of government which are all independent of each other to a certain extent, as well as no one branch of the government is authorized to get rid of the other branch or to operate above the head of the other branch, or to be contentious, as this gentleman continues to be, in regards to the House of Representatives and the Legislature and the Senate, in regards to the Supreme Court or Supreme Law of the land. They keep bastardizing the legal system, and then they take the Treasury and hire lawyers to defend the indefensible, that is, their criminal conduct. Because as lawmakers, as I previously stipulated, they're entitled to make changes to the Constitution. But what they want to do is eviscerate the Constitution, not make changes to it. Because the Constitution is a living document and it says to them what their limits are in terms of tampering with the Constitution. And because the Prime Minister himself has said in more than one occasion, in public and on the airwaves, that there are parts of the Constitution that's constraining him from governing the way he would like to govern, which for all intents and purposes is saying that he wants to govern a certain kind of way and the Constitution is constraining him, so therefore he go ahead and govern the way he wants and to hell with the Constitution. That is to say, he bastardizes our Constitution, the very Constitution that he swore allegiance to when he took the oath of office. That was required of him before he was granted the privilege of governance. He had to win the election, then he had to go to the Governor General for ascension of powers, executive powers, to manage the country. And in so doing, before he is granted those executive authorities, he has to swear allegiance to the head of state, and he has to swear allegiance to the country and fidelity to the Constitution of the country. But as soon as they go through those mechanics to acquire the power of governance, they take off and then they go and just do all kind of evil and mischief-making conduct. And because they don't hold themselves to account, or they don't arrest themselves when they commit crimes under the color of law as lawmakers, they seem to believe that they're immune, and with impunity they continue to haul and pull the system and render injustice rather than justice, to the point where a few civilians decided to go to the courts to get a constitutional review on the constitutional violation. because the prime minister had promised that if he got elected, he was going to take care of it. He had used the whole term, didn't take care of it. He got a second term now, and is still playing games and wanting to wait another couple of years before he decides whether or not he's going to take it up or deal with it. Something that should only take less than 3 minutes per division to accomplish that task by one person, as we showed them on this particular platform before. To do what is required to be done for one division, they have all the assets and all the reports available to them in the Election and Boundaries Department. So if they have 31 division and the matter can be dealt with 3 minutes per division, we end up with less than 100 minutes of work. Which is to say, you have approximately a little over an hour and a half worth of work by one person, if they really sincerely and honestly wants to accomplish the task. Let's say instead of giving them 3 minutes per division, you give them 6 minutes per division. That gives you 3 hours. The matter could have been dealt with in 3 hours. This jackal is going to come and tell the public, oh, he'll think about it and maybe adjust it in the next 2 years. That's the level of contempt that I'm referring to when I say they're contemptuous towards the people and the Constitution. Because they go to the court in the first case, case number 55 of 2019, and they acknowledge to the judge that they're in violation of the Constitution and they're non-compliant according to the requirements and the prescriptions of the Constitution. And they ask the judge to encourage the plaintiff that brought the case, the civilians, to give them a chance to go and correct the errors, or not, I wouldn't even call it errors at the time. The violations is more appropriate to say. And the judge, under that judge's jurisdiction, is going to encourage and allow the plaintiff that brought the matter to the court in the first instance for judicial review. That judge is going, as a matter of fact, I'm also going to go ahead and call name. Judge Navy decided to play hanky-panky with the government, exculpate the government from having to have a ruling against them, and then bamboozle the plaintiff who brought the case to the court for review. Instead of the judge rule on the merits of the constitutional violations, she went ahead and under her jurisdiction, because the court, that particular case was under her jurisdiction, she held control over that case until the case would have been disposed of. And the case should not have been disposed of without dealing with the substantive, illegal, and constitutional violations. But for all intents and purposes, that's how the judge decided to make the case got terminated. That is, under her authority, the plaintiff and the government entered into what she then later on classified as a tumbling agreement, and claimed that because that the client had agreed to go ahead with the government, to give the government the time to comply with the constitutional failures, that the client then would be barred from being able to continue the case any further. And that as a result of accepting the side agreement, the client case was then stifled and the client could not go forward with the case. Even though the agreement stipulates that the government had a responsibility to do certain things, to be in compliance of that agreement, or to justify that agreement being entered into. the judge is going to turn around and tell the people, the clients that brought the matter to the court, that they were precluded from having her make any ruling on their behalf. And that is how she would then get out of the responsibility that she as a judge had for ruling according to law and ruling according to the Constitution, and therefore ruling against the government. Why? The government had a contract over her head, and she didn't want to find herself ruling against the government or falling afoul of the government. So it was easy for her to claim that she couldn't help the plaintiff to have the matter judiciously reviewed. That was a bastardization of our judicial process. That did not comply with Section 95 of the Constitution, nor did it comply with Section 20 of the Constitution of Belize. Nevertheless, in her when she made the ruling to kick out the case, she also stipulated she was not addressing the substantive case that was brought originally, and that she was then only addressing the issue of the plaintiffs asking her to sanction the government and to force the government to comply or to come into compliance. She did not perform as she should have performed, that is to demand that the government come into compliance, but she went ahead and accepted the premise that because the agreement existed and that the government pretended to be doing something to address the matter as specifically mandated under the agreement as well as the Constitution under Section 90, that the judge was exculpating the government and taking the government words for it and accepting what the government was promising, then as being good enough to stifle the case, to, for all intent and purpose, throw out the case. While she was throwing out the case, she was still claiming that, well, somebody else might have the right to bring the same case, but this plaintiff cannot because the plaintiff had entered into an agreement. The least she should have done, if she had any serious judicial proper temperament, would have been to address the constitutional matter, because that case should not have closed without the constitutional matter being attended to and addressed. So now, because she had said that somebody else could bring the case, somebody else did bring the case in the second instance of the case where Mr. Roody Wade and his colleagues filed to the court of Belize, the High Court of Belize, for injunctive relief to have the government do not do any elections before they complied with Section 90 of the Constitution. And when the matter was first brought to the new judge now, the first thing the new judge is going to query from the plaintiff is, wasn't this matter dealt with before in the previous case? As if to say the judge had not done his work, the second judge had not done his homework, that is to review the first case before making comments on the first case. In other words, she should have been appraised of what the facts were about the case. But the first thing the judge is going to question the lawyer is, doesn't this case have a bar for it to continue or to be able to be brought back to the court? And the bar is because the tumbling agreement was ruled upon. Therefore, by exaggerating the legal point, that is, if you have an agreement and the agreement is laid to rest without having dealt with the court case itself, or without having dealt with this constitutional violation itself, without sanctioning the government for accepting that they're in violation of the Constitution and by giving the government a pass so that they can continue to violate that very same constitution. That judge did not have proper judicial temperament, because the first thing that judge should have done before asking that presumably prescient question was to appraise himself, because it's a him in the second case, is to appraise himself according to proper judicial temperament, know what the facts are before he opens his mouth and make any kind of statement that did not comport. That is, here's the plaintiff lawyer. Is there not an estoppel, which is a legal term, on this case? That is to say, are you not barred from bringing this case forward, or from allowing or asking us to allow you to carry this case forward? And I'll explain something to you, the general public, right now, okay? Just as how he brought up that term about the estoppel, for there to be an estoppel, there must be a res judicata. That is to say, in legal terms, the case must have been brought to rest by judicial conclusion or decision. A res judicata is when a case is brought to its conclusion by judicial merits or decision. The first case that we referred to earlier was not brought. There was no judicious conclusion to that case in terms of the merits of the case being dealt with and adjudicated. It was never adjudicated. What was adjudicated was the side agreement that the judge decided to accept the government's promise that even as of today date that we are having this conversation here, or at least I'm making this statement to you, the general public, the government is still in non-compliance. So how the hell that judge would have then given the government one excuse to get off from underneath the criminal conduct that they were carrying out with, and had already acknowledged to her, that same judge, that the government was telling her that the government acknowledged breach of the Constitution and would pursue the effort of rectifying that breach. As of today, they have not rectified it. They lied to the judge. They bamboozled the client, the original claimants. And then now they're coming to the second judge with the same shenanigan. That is that, first of all, I want to tell the judge, throw the case out because the case has already been ruled upon, which it has not been ruled upon. They know that, but that's the kind of game that they want to play. That is, do not abide by the Constitution, do not follow proper judicial temperament, do not follow the precepts, the principles, the practice, the procedures and protocols that the courts of justice or the course of justice requires. And then they get handsomely paid. Because, for example, the lawyer that was defending the second case on behalf of the government was two of the highest paid lawyers and biggest law firms in the country, to go up against one single lawyer that was willing to take up the case on behalf of the plaintiffs. Then they submitted into evidence over 600 and odd pages of documents, very little of which had anything to do with the case or the complaints. They refused to adjust the complaints because, as defendants, it was their requirement to defend the case that was brought against them. They refused to adjust any of the claims that was brought against them. And they submit 600 and odd pages of documentation to create a different case and to answer to that new different case that they wanted to have the judge play around with, instead of the judge focusing on what the government had already agreed that the government was in violation. At that point, the judge, all they had to do was make a ruling that you acknowledge being in violation, you need to go and correct your violation, and based on that status, the judge could have made a ruling, and the judge and the government would have had to go and correct. But the judge gave them the pass. They pretended that they was going to go and correct, and didn't correct because Section 90 has requirements in there that they failed to correct, and that they said that they wanted the agreement so that they can go and correct. They're a bunch of scoundrels. Nevertheless, as I said, this second judge now, who holds this last case for final judgment, because all the hearing has been done, but he has not issued his ruling. And based on how the hearing took place, it's quite conceivable that this judge will follow the same shenanigans like the previous judge had done, and rule to say that there is an estoppel on this present case because the matter was adjudicated before. When in fact, anybody that knows anything about law or legal matters or court procedures or precedents or judicial practices would know that in order for you to have an estoppel, or in order for you to have a block, or in order for you not to be able to carry a case forward, that case must be ruled upon before, and it cannot be brought at that same level. You have to go above that level for judicial review, as in a case where you want to have an appeals of that particular court case. But in order for you to have an estoppel or a block, you have to have a res judicata. You have to have the case being disposed of legally, properly, and judiciously. You can't answer to another case that is separate and distinct, which the agreement was, in terms of saying because they dealt with the issue of the agreement as the first judge said she was doing. That means that the rest of the case, for all intents and purposes, was also adjudged or ruled upon. There was no such thing, because she, the same judge, said if anybody else wants to bring that particular issue, constitutional violation, forward, they're within their rights to do so. And I agree with her on that particular point, because anybody in Belize, as a voter, have the right to feel offended about this violation and have a reason or a cause to bring legal action. Then they want to say that the new action that was brought is one and the same as the former action. So that was the reason for the judge asking the first question that he asked when the second case was brought up. When he said if it doesn't have an estoppel, an arrest judicata status, as if he had not read the material before him, the pleadings, for example, or he had not read the conclusion of the previous judge, as to find out or know then that the judge was stipulating that she was ruling only on the request that the plaintiff was making to sanction the government for non-compliance. And the non-compliance was not the non-compliance of the Constitution, but the non-compliance of the agreement that was entered into. They are two different things. And all these, for example, Mr. Courtney, he gets on the airwaves, and he's talking craziness or stupidness that the plaintiffs did not submit the 800 odd pages of document, 600 of which he had produced. So he's blaming the plaintiff for not bundling his submittal and make that available to the court. That's his job. And in that 600 odd pages, most of it was just the history of the Department of Elections and Boundary. It had nothing to do with the merits of the current violation of Section 90. So I'm led to believe that because they try to push the case away from dealing or ruling on the violation of the Constitution and try to rule on the basis of another technicality, that is that, for example, if they can prove, or if somehow or another they can justifiably say that this matter has a res judicata status, and therefore, as a result of the res judicata, which means that as a result of the matter having been adjudged correctly before and dealt with and laid to rest, the term rest, the two word phrase res judicata. Judicata is meaning or interpreted as by judicial review and decision and finality. So you have a res judicata, if that was to be true, and as a result of that res judicata, then you have an estoppel. None of those conditions existed in none of these previous cases, and yet that is the way they want to have this case ruled, so as to say, well, kick the case out, so that the government doesn't have to have a ruling against the government, and that the judges don't have to fear that the government is going to terminate their contract and ship them abroad. Okay, that's really what's at the bottom of the whole of this nonsense. And the government is contemptuous to the point of not having done it the first time, refusing to do it the second time, and now trying to pretend that they could just be snobbish. And since the judiciary can't force them to do what they need to do, and they don't want to do it, that they will just prolong this process. And since the judiciary is also giving them a pass and stifling the cases that are being brought to force the government under judicial. At one point, they were even trying to say that because the matter included electioneering issues, right? And because it is required to use these processes that they do at the Election and Boundary Department to conduct elections, which they are mandated also by the Constitution under Section 88 and 89, as well as 90 and 91. They are mandated to operate in a certain manner, and they refuse to operate in that particular manner. Why? Nobody can force them to do so. The Constitution, as a document, won't get up on its foot and go force them and or do it, on its own, because they have the authority vested in them. So if they fail to do what's right, then nobody else have the opportunity to correct their failures. I just want to read a little part here of this from the case itself. Okay, I made reference to two cases, and I want to read a little part here that I made reference to as well in the case of the claims number 730 by Mr. Roody Wade and others. I should probably just go ahead and read the name of the others just out of basic decency. The case was between the government of Belize, that is the Attorney General responding on behalf of the government, and then you had the Election and Boundaries responding on behalf of the Election and Boundaries was the chairman of that Election and Boundaries Commission, and they all had legal representation. In other words, other lawyers who came to represent them. And then you had Mr. Rudy Lewinsky Wade, whom I referred to earlier, and then you have Mr. Hubert Dennis Enriquez. Then you have Mr. Paul Marcel Morgan. You have Mr. William Mejia. You have Mr. Godwin Bernard Sutherland. You have Mr. Antonio Giovanni de la Fuente. And last but not least, you have Mr. Uh, Roberto Antonio Lopez, all registered voters in the country of Belize, all of whom individually should have standings to be able to bring just about any of these cases, and should be able to have standings, like I said, and their standings should be recognized by the court as is required under Section 20, because under Section 20, which covers uh, judicial review for Section 3 all the way through Section 90 inclusive, where all the separation, not the separation of powers, the rights and the freedoms exist, and when they are being violated, for example, in this instance, Section 6 is being violated, which states that all persons are equal before the law. So there is the equality clause there that's being violated. You have, for example, under Section 16, which says that people are not supposed to be discriminated against. So if you have Section 90 mandating that the election and boundaries perform a function such as making sure that the electorate is divided into such numbers that are nearly as equal to each other in each division, and they are going to claim that they have done so by having 2,000 persons in one division and 10,000 in the other division, and that constitutes fulfilling their constitutional obligations and their mandate, then that's laughable. Okay, you can't even get kind of addition or subtraction or numerical comparison to a second grade kid, that they won't see the difference and realize that you're trying to fool them or make a fool of them. But yet these so-called honorable people in the House of Representatives refuse to deal with this matter adequately and forced the election and boundaries to go back and do what they had promised in court that they was going to do. The Prime Minister sits on this matter, sends it into committee, House committee, to go and die. And then he turns around and says, well, it's the fault of the election and boundary for not having presented a credible recommendation. But yet the judge is going to accept that recommendation, which is not credible by the Prime Minister or by us, the general public who are paying attention to these matters, but is accepted as being credible by the judge. And then the judge is going to obfuscate the fact that she, in the first instance, was hiding behind a promise that was made to her in order to exculpate the government from fulfilling their obligation. Her job was to have made a ruling. She failed at that. And that ruling should have, according to Section 95 of our Constitution, where the power is granted to her and all other Supreme Court judges, to adhere to the Constitution faithfully. Let me go ahead and read the rest of the stuff that I was trying to read. In the response to the second case, which was case number 370, 730, I'm sorry, case number 730 in the Supreme Court of Belize for 2024, there's quite a few submissions here, but I don't want to read all of them. I have a few that I specifically wanted to take up. For example, 7. Let me turn this thing sideways so I could get a bit better visuals. Okay, 7. One more. Okay. Number 7 goes as follows. Before I leave the point that I was on just now, according to the Constitution of Belize, Section 95, it was the responsibility of the judge to take a look and see whether or not compliance was being had by the government. When those people brought to the judge's attention that the government was refusing to comply with the agreement, it was then the responsibility of the judge to look into that matter and see if really that was the case, that whether or not the government was in compliance or whether or not these people were just, being overly, like if they weren't too sure or didn't know what they were talking about. That was the judge's responsibility as the person who holds the case or controls of the case. If the judge had looked in and seen what everybody else was seeing, the judge would have been in a better position to make an adequate ruling, a proper ruling, or to make a ruling according to Section 95. Because it also tells you in Section 95 how is it that a judge goes about exercising the powers vested in them. Okay? But the judge didn't do the simplest and basic thing, which was take a look and see. Verify for yourself. Because you have authority that you need to exercise and is required to exercise. And in the exercise of that authority, you must be judicious. You must rule according to law. I'll read number 7 on this response that the respondents made, on behalf of the government, and in this response that they made, they conflated, they lied, they bamboozled, they stipulated quite a few things that were not correct or truthful. So on that basis alone, they should have been sent to jail for contempt of court. Come to the court and make misrepresentation, knowing so. He says, after much negotiations, that's the impression they're trying to create, that there was so much negotiations, that validated the dastardly outcome. On claim number 55 of 2019 was resolved. He says that claim was resolved, which is a lie, because what I just told you earlier, by now, having said what I said, most people having heard what I heard and what I said would recognize that they did not comply and there was no agreement made that validated compliance. An agreement was made for them to go and comply. And the judge kicked out that agreement without them complying. And then now these idiots are going to go and say in their stuff that they're submitting that yes, there was compliance and that there was this agreement entered into, and the agreement was, for all intents and purposes, complied with. Therefore, which is why they're trying to go in the direction they were trying to go when they were making their presentation. But I'll just continue reading because I'm doing the reading because I want people to get an idea of what is it that we know, having read the presentations and followed the case and everything else. Just what we are saying should not be enough for people to understand what had happened. So let me read, like I said. And as a matter of fact, I'm going to start reading this. It's not too long. It's less than 100 words. Number 7 says, after much negotiation, holy Toledo. Okay. I'm sorry. I touched the screen just now, and the material disappeared off the screen, so I had to retrieve it. I'm sorry about that. Okay. So it says, after much negotiations, claim number 55 of 2019 was resolved by was resolved by compromise. That is, that there was a compromise made between the parties, which was a lie. It was not resolved. There was an agreement made, and in the agreement it stipulates that the government is asking for the opportunity to not have a ruling against them, having acknowledged that they were in breach, and just to give them the time to go and correct the violation, which is what the client was asking for. The client wasn't asking for no money. They wasn't asking for nothing punitive to the government, because it's our own government. They were asking the court to make a ruling to have the government go and do the job. So the government decided, okay, they won't accept fault and they won't ask for the time to go and do the job. But that was just a bogus ploy on their behalf to not have the judge make a ruling right there and then. So they entered into this agreement with bad faith to start with, knowing exactly what they were planning to go and do. And they went ahead, used the time, pretended that they was going to do something. They never do what they were commanded under Section 90 to do. And the plaintiffs, they came back and complained to the judge that the government is still resisting doing what they need to do. And instead of the judge look under the hood of the car and see what caused the problem, the judge just said, okay, well, I can't help you. So what the hell do we have judges for then if she can't help? If she refused to do her job, we can't force her to do it because she's on a contract by the government, not by us, the civilians. Yet. Under an agreement which, according to the stipulation here, resulted in a consent order, referring to the very same agreement, which was dated on the 29th day of November, which was correct. You see, they mix up, that's why I call it a conflation as well as a bamboozling, right? Because they mix up, like, for example, something that is true, for example, the date was true. They mix up, they add the part that is true, that there was an agreement. But as I read along, you'll find out that the agreement was not held, it was not abided by. So the agreement did not work the paper it was written on. But they want to claim that because of that agreement that was had, it means that the case must be thrown out. Okay, and that was 29th of November of 2022. It says the consent order. Now remember, a consent order cannot be entered into by a plaintiff on their own, right? An order comes from the bench, from the court. It is the court that allows a consent order to be entered into. And that is because both parties are consenting, so therefore the judge allows it. But the judge already knew that the government was in non-compliance. So when these people come back and tell the judge that, yes, you encouraged us to enter into this agreement, but that the agreement is not being fulfilled, how then can the judge who sits on the case and who has the authority for the disposition of the case have any gall to turn around and tell the plaintiff then, well, she can't help? What the hell is she there for then? That was part of the case management of the, in that particular instance. She managed incorrectly. She encouraged something to happen under her jurisdiction, and then turn around and want to blame the people and what it happened to, and claim that she has no ability to be able to help them. It's a constitutional matter that she is responsible for dealing with, but she won't pull herself from underneath it by stifling the people in case, and for all intents and purposes telling them get out of her face that she don't need to be bothered with them anymore. Come on. Anyhow, so the consent order was entered into, A copy of the consent order is here to exhibited as noted as EM2. That is what the government side was presenting on their behalf. At that time, that was the Solicitor General, a lady was the Solicitor General at the time. Her name is a little bit farther up on the document, and I can only see one part of it at a time because I'm using my phone, like I said, no. Um, so she made that declaration, which was outrageous on its face, but at the same time stipulating stuff, conflating stuff, and misleading, making misleading statements, as if he wasn't aware, of other contemporaneous facts that merited her bringing to the attention of the judge. But they want a certain outcome. So if they have to lie to the judge, conflate to the judge, or misrepresent to the judge, according to them, that's what they're supposed to be after. And if the judge doesn't know otherwise, then the judge may not want to sanction them. And in some instances that I'm aware of, in this particular instance, the judge did not sanction them, even when the judge realized that they were contemptuous. Why? Apparently, according to her, her job is to facilitate the government's desire to do just about what they want, even at the expense of violating the Constitution. So, in other words, she did not recognize and realize and or step to the plate and abide by the powers that allow her to exercise judicial efforts in the country. It is the Constitution that she is supposed to be validating and vindicating that gives her the powers to exercise on behalf of the Constitution and the people of Belize those powers and authorities, and to render decisions within the context of the law, not to bastardize it. I'll read number 8. It says, therefore, number 8 reads as follows. Therefore, the effect of the consent order was a settlement of the claim, and that is boldfacedly wrong and a lie. You see now when I'm telling you guys that they go to the court and lie and conflate and misstate facts, deliberately so, as a matter of fact, the Solicitor General knew herself that this statement that she was making to the court, as I call it, a misrepresentation to the court, was a lie, a bold-faced lie. Because how can she stay, as I clarified earlier? Therefore, as a result of the consent order that they had entered into to go and correct their errors, that consent order then, according to her, trumped the Constitution. And therefore, the effect of the consent order, according to her, was a settlement of the claims. How the hell that going to settle one consent order that they entered into that they did not comply with in the first place, again, as I'm saying? How the hell can she classify that as a settlement of the claim? And the claim was about constitutional violation. And the consent order was for them to go and correct their constitutional violation. How they could turn around now and claim that just by entering into that side agreement, the matter is resolved. The matter is resolved when that agreement is fulfilled, when they go and do what is required of them under that agreement. They didn't do so, but they want to say, by virtue of having entered into the agreement, that settles the case. That's what she's saying here. Okay? As a matter of fact, I should read it over again because I just want it to sink in at people's head, right? Therefore, the effect of the consent order, according to her, was a settlement. Now, this person is a lawyer, Belizeans at home and abroad, or those who are hearing my presentation, the Solicitor General is a lawyer. She works for the Attorney General's office to represent the country legal issues in many departments. So she, as a lawyer, is going to say this kind of contentious stuff to the court when she damn well know that entering into that agreement did not constitute dismissal of the case or let me read her own words, right? Okay, let me not use my own words. Therefore, the effect of the consent order that they entered into the plaintiff to give them time to go and correct the egregious constitutional violation was a settlement of the claim, as it was agreed that all proceedings would be stayed. What I mean there is that the case that was going on in court, that they had already acknowledged that they were in violation of the Constitution. At that point, when they asked the judge to let them have an agreement with the plaintiff who brought the case, they're saying that by them just entering into that case, that was like a final nail in the coffin of the allegations against the government. That then the government could just go ahead on the basis that the judge authorized them to enter into that agreement. That agreement was then substituting the whole case, or bringing to rest the whole case. And they're supposed to be lawyers, thinking and talking that kind of way. And the judge, after the judge reads something like this, the judge should be mad like hell. Because in the first place, it's not proper presentation. It's an allegation without merits, that they're just making an allegation, and to try and pretend that, well, because they say so, that's how it is. By judge. As they say here, as it was agreed. Now, the plaintiff did not agree to anything such as what she's stipulating here. Okay, so she's trying to get this in the mind of the judge and anybody else who's hearing or listening to the case. It says they agreed that all proceedings would be stayed. Save, when I say save, it means other than or for the fact of, for the enforcement of the term of the consent order. That is, in other words, nothing else will happen. The judge is not going to rule against the government. Basically, that's what she's trying to intimate, which did happen. Why? Because they are making a promise now in the consent order, while they enter into the consent order, to go ahead and correct their constitutional breach. And therefore, everything should stop. That doesn't mean that because they enter into the consent order and they don't fulfill their obligation to the consent order, that means then that they automatically have a reprieve from compliance. Only an idiot would think that that's the case. They still have to comply with the Constitution and with the consent order. But here comes the judge. When the people that went back to tell the judge what was happening, the judge said, well, I can't help you. You enter into an agreement with the government. If the government will take advantage of you and no one comply, tough luck. Because I'm not going to order the government to comply. For all intents and purposes, that's what the judge was saying. What kind of judicial temperament that judge would have to have in order to arrive at that kind of mindset? She has the right to dispose of this case, and she's going to dispose of it underhandedly, right? By not rendering justice, by not having any fidelity to the Constitution, and by having more allegiance to the government. In other words, for all intents and purposes, that's those kind of behavior is what aids and abet dictatorial practices in countries. And our country is supposed to be a democracy, by the way. So the executive then rules over and lords over and controls the judiciary and determines the judiciary output, because there's a contract over the judiciary's head. They don't want to offend the government. And since our system in Belize, the ones that gets the majority elected to the House of Representatives constitutes the government, the executive. They are the one that goes to the Governor General for ascension of power to become the executive. So they run the House, they run the executive, and they control the judiciary by importing and giving contracts to shady judges like these. And they know that the people that are bringing the suit don't have money to go up to a higher appellate level. Because at the appellate level, you got judges who are more seasoned and who know the worth of their salt and would not necessarily bend and kowtow to this kind of misbehavior at the lower level. So therefore, this matter could have been overturned if those people had enough money to go one more step. But they will put them in that kind of a bind to say, well, we know you can't go the next step, so we can just block you off and put you in an untenable situation. I got 1 hour and 1 minute. Okay. I think I have another few minutes left. I'm going to read some more of this part here because I really want you guys to get a feel or a flavor of what is it that the people in Belize are contending with when even their one judiciary, who should be upholding the law and rendering justice, are making a mockery of our processes. It never used to be like this before until we have these other people that come with allegiance to their paycheck rather than to their professional ethics and morals. As regards to the consent order, I'm going to read number 9. Right? I just read 7 and followed by 8, and I'm going to try and read 9. 9 is not too long either. It's very short. So let me just indulge in reading this. Hopefully, I'm not wearing out people. I'm not making people get tired or frustrated. I am tired and frustrated. I'm the one doing the presentation, and I'm the one that had to go through all this craziness with these people and see their misbehavior, and swallow my spit or my my thoughts, in regards to how I think that these people should be dealt with. But at the end of the day, judges are authorized and given the privilege and opportunity to make rulings. When a case comes to the judges, it's their responsibility to make a ruling on that case. But it is also their responsibility to rule judiciously, which is why the matter comes to them for jurisprudence and judicial activity. They shouldn't be acting in shady ways. Let me go ahead and read number 9 as I indicated earlier now. And it reads like this. The parties, that is to say, the people that are being sued and the one doing the suing, the parties agreed in paragraph 1 of the schedule of the consent order. That is, the consent order has different paragraphs that stipulate different issues, facts, opinions, ideas, or concerns, or desires, And in that schedule of activities or numbered activities, some of them are on behalf of the plaintiff and some are on behalf of the defendant. But the Solicitor General of the country now is trying to intimate, according to her, that the parties agreed in paragraph 1 of the schedule of the consent order that given the current, which is okay, given the current distribution of registered voters in Belize, right, which is the point that was being argued about, or at least one of the points that caused the matter to come to court, that given those, given the circumstance, that is that the divisions are malapportioned, right, and there may be the need to have more divisions or the same divisions or maybe less if they are portioned in a certain kind of way, right? There are ways to do it and do it right easily. Anyhow, because both parties agree in the first item number 1 on the schedule that the reapportionment is not correct, it was necessary to, let me see. It was necessary to consider the redivisioning and re-registration of the votes and to make recommendations for amendments to the first schedule of the Representation of the People's Acts, ROPA, to rectify current electoral boundaries. That is that in the first statement in the agreement that they entered into, both party acknowledges that the stuff that what the election and boundary had done and was trying to use was not consistent with the laws or the Constitution. Okay, both parties agree that that was the case. So then why didn't you just go ahead and rule and say, well, if you know that's the case, why are we even wasting time here in court? You know, I'll make a ruling and you go and take care of business. And under that ruling, you're compelled to do what's constitutionally required. No, that's not what they really wanted. They wanted to hoodwink the plaintiffs because, of course, the plaintiffs who brought the matter, none of them were lawyers. And they only had one lawyer that was willing to, out of all the hundreds of lawyers that we have in the country, only one lawyer was willing to take up their case on their behalf so that they didn't have to end up in court unrepresented or without a lawyer. Those are the odds that the average person has to fight against in terms of getting their rights vindicated. Okay. So that was 9. I want to read 10. 10 is a little longer, but it's a little bit more self-explanatory. That's why it's longer. Let me go ahead and read 10. It says, in paragraph 2 of the schedule of the consent order, the Election and Boundaries Commission agreed to identify and explain in a written report its recommendations for the redistricting. In other words, they're willing to put on in black and white their deficiency, and then later on they're not willing to honor it. Why? Because they're given exculpation by the judge, who has the final say. And they're supposed to, for redivisioning and redistricting in accordance with Section 90, as I previously stated earlier when I was making my verbal comments. Section 90 of the of claims number 55 of 2019 on the date of and the date of receipt, it laid before the National Assembly or on the 17th day of July of 2023, whichever was earlier. Um, it indicates that the government was making a commitment to do the redivisioning and the reapportionment and lay it on the legislative desk in Congress for Congress to debate and sanction into law. And they were supposed to have complied with Section 90, which is to make the divisions nearly as equal. They refused to do that. The election and boundaries used money to do a sleight of hand effort and claim that they had done something, therefore they need to be exculpated from under the jurisdiction of the court. And the court abides by that, tepid, well, I would say more than tepid, I would say that conniving undertaking, and let these people off the hook. Because by virtue of them, instead of doing what Section 90 requires, nearly as equal, they went ahead and maybe changed probably about a few hundred here and a few hundred there, maybe a little 2 or 3% difference, and submitted it under the claim that, well, they had done what was promised in court. And all the judge had to do was look under the hood of the car, and you may see that they had not complied. They did not do what they had asked her to encourage the plaintiffs to do. That is, give them the chance to make them go and correct. In other words, they could have gone and correct 20 times in a row and still refuse to comply. Does anyone realize that to be a reality? Because they could have changed by 1% the first time, go back and change by 2% the next time, go back and change by 3% the next time, and go back and change by, 4, 5, 6, 7, 8, 9, 10, 20, up to 30%, 50% probably. And they still wouldn't have gotten an equal amount. Whenever you have one district that have 2,000 people and another district that have 10,000, that's 5 times as much. That's 500 times or 500% difference. So like I said, they could have gone back probably a dozen times and changed on 0.5% here and 10% there or whatever, and still not get to compliance. That's what rascals do when they don't want to do the right thing. But they didn't even go that far. They decided to just snub the whole process and do just about nothing, and just carry a report to the House that they knew wasn't going to be accepted by the House, because the House is led by the majority who constitute the government and the Prime Minister, who appoints the leader of the election and boundaries himself. So the Prime Minister have majority in the election and boundaries department, in the election and boundaries commission. So they decide what they want that commission to do or not do. And from the get-go, they had decided that they didn't want to comply or deal with the matter. Therefore, the best thing to do was just to play the fool, go along, pretend like something is happening, and then turn around and blame the election and boundaries for it, not having complied. While the judges are exculpating the election and boundaries because they take the word of the chairman, Mr. Sabido, above the words of the plaintiff, and throw the plaintiff the case. I won't read any more of that. It's a little, these are the kind of things that lawyers talk about and deal with in court, and sometimes even the lawyers, they get tired and frustrated, and even the judges sometimes they get tired and frustrated, and they call for a recess, or they change the date, or they, So I don't expect that the average person listening to such a presentation that I'm trying to make here right now will necessarily have the patience, the knowledge, the understanding, the ability to contextualize and rationalize what is it that I'm trying to advocate here or verbalize here. Um, like I said, lawyers go to court and they argue these things back and forth against each other. And it's not always the best or the sharpest lawyer that win. You have the best case, as in this scenario here with these people. They have a winnable case. The government doesn't have a leg to stand on, having acknowledged that they're in violation. But the judges still, facilitate them to have the outcome that they want, and to hell with the plaintiff and the Constitution. And on that basis is why I say it is sad for my country. I got about 5 minutes to go, so I'll just get to a position where I can wrap it up and just let me just do a small reading here from something else that I've done earlier. Come on. Could I? Shucks. Okay. Okay, let's see. Where is it? Holy macros. Oh, okay. Let's close this. Okay. I'll just yeah, okay. I got it. I had made some citations, some of which I read in the last presentation that we did on Friday for the constitutional review on Fridays that we do. And then prior to that, on Wednesday before then, and on the Monday before then, we had cited some of these very same constitutional citations from the Belize Constitution. I want to go ahead and read a few little parts of the next 5 minutes that I had. Not five, I got about four. Okay. Let me go ahead and read it. It says the Belize Constitution violations under Section 90, which we just referred to earlier, and under ROPA, which we just clarified as well earlier. Schedule 1, inconsistency, etc. There's a group of citations here, such as Part 1, Section 1, and Section 2, Subsection 1, as well as Part 2 of the Constitution, Section 6, Subsection 1, and Section 16, Subsection 1 and 2, and Section 20, Subsection 1, 2, 3, all the way through 8, as well as Part 7, Part 6 of the Constitution, relating to Section 88, Section 89, Section 90, and Section 91, and Part 7, Section 95 of the Constitution of Belize. Then I have, in addition to pointing out these citations, I have bits and pieces of the citations themselves in worded out or worded in, in terms of being accessible for reading and review. But I don't want to deal with them right now because we dealt with some of them before on the other nights. And I'm running out of time. I only have, like I said, about 3 minutes left probably by now. And so I want to go to the last one of these items, Section 95, and just read Section 95 so people can get a context of what is it that is required or mandated of these judges that I'm complaining about. in regards to their conduct. Uh, Part 7, Section 95 of the Belize Constitution reads as follows. The Belize Supreme Court, that is, the High Court of Belize, under Section 95, subsection 1, all the way through 4, which I'm not going to read all of them, by the way, inclusive, states, Section 1 states as follows. The Supreme Court shall have unlimited original jurisdiction. That is to say that any case brought to the Supreme Court has the power and authority and the requirements under this present constitution that we have in Belize to see to it that they dispense justice with proper judicial temperament as well as justicious fidelity. In other words, to say, if something is justicious, if something requires the justice and the judicial system to get involved with and clarify or help, then the Supreme Court is the venue that has original jurisdiction and should tolerate or allow for people to have judicial redress to whatever ails them or is their concern. I'll read on quickly here. It shall have unlimited original jurisdiction to hear and determine any civil or criminal or outright constitutional proceedings under any law, and such jurisdiction and powers as may be conferred unto it being the Supreme Court, by this constitution and or any other law. So I wasn't speaking out of turn or overemphasizing unduly that the Supreme Court has a critical function to play in our country as one of the three arms of our governance system, and it has unlimited original jurisdiction. The legislators make laws, and those laws must comport to the requirements of the Constitution, or they must work within the boundaries of the Constitution. And whenever the legislators make a law that is unconstitutional or is violative of the Constitution or breaks the Constitution requirements, then it is for the Supreme Court to pronounce the legality or validity of that law, not the legislators. They can make any law, as many laws as they want. But if it's not constitutional, if it's violative of the Constitution, if it's illegal or unconstitutional, it is illegal, and it is unconstitutional. The fact that they make it doesn't make it constitutional. They can't pronounce it constitutional. That's the responsibility of the Supreme Court to make those pronouncements. And on that last point, I'd like to say thank you for sparing your valuable time to listen to my presentation tonight. It had a lot of legal mumble jumble, and I would have liked for it to have been presented a bit more wordy, like in more words, in other words, so that I could clarify or explain more of some of these things as we were talking about them. Because not everybody understand or know or following the cases as they were going on. And currently, we have this outstanding case that the decision needs to be handed down. And we are waiting with bated breath to see what the judge is going to stipulate, because we saw what he was stipulating initially, and it doesn't comport to the constitutional requirements of our country or the legal system in which we have survived and lived. And I just want to say thank you very much for your time spared, and I hope you have derived some positive public benefit from spending your time listening to this particular program tonight, which was the Belize Affairs program number 283. Good night. God bless Belize and Belizeans at home and abroad and everybody else. Goodbye.